I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job. But at this point, we just need to get the case set for whatever it's going to get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for trial.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay. All right, then. Well, I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion.
Okay.
Because I would consider that new, obviously, if he has to sit and wait for another trial docket. Okay?
Thank you.
All right, thank you.
You're there. I just see you.
That's an order for a setting.
Well, no, sorry.
Mr. Gertz, you have Giovanni Coleman. Morning.
How are you?
Good. How are you?
See how it goes after this.
Yeah?
Belfast.
All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first degree felony offense of murder. And what is the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So,
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. And so we're asking for.
And Judge, if I may, I just put my spin on that.
Please.
I
And here's my
would not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these self-elevated first degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're going to do.
doable.
You've been on since last May. So we're record. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before. Now you can keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations was.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving and then causing the vehicle to crash.
We naturally going to disagree with her version of the facts.
Can you hear me, Mr. Nichols?
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McQuaid were in a relationship, and this was a fight that escalated. change since the last time is he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron
Electrical.
Electrical. He's a electrician and would go there and work and live at home with his parents. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm 14 months into your representation. I'm last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not. And then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This will be the last one.
Okay.
Okay? All right, you go back with the bailiff.
And that should also dispose of the co-defendant for employees as well. So
Okay.
you kind of keep them staggered, and then maybe it would take your 2-1.
Thank you. Jacorian,
Only-
thank you.
Okay.
Make sure you make that notation for me, please, ma'am. And did you get in touch with Mr. Cole? You're charged in cause number 25, DCCR 0211, with the state jail felony offense of solicitation of prostitution. And that's from December 19th of 2024. And how do you plead to that charge?
Culpable.
Guilty.
Are you pleading guilty freely and voluntarily?
Está suplicando culpable libre y voluntario. Tienes que decir sí o no.
Nobody's making him plead
Que
guilty.
nadie está diciendo que tienes que decir culpable, ¿verdad?
Answer out loud for her, please.
Yes, Judge.
Are you pleading guilty because you actually did what they charged you with?
Y estás diciendo culpable porque existe lo que le está diciendo que existe. Que sí existe el cargo.
Sí, culpa.
Yes.
I have here on the tablet some documents that have your signature on them
Tiene unos documentos a mi tablet que tiene su firma,
that the state's marks as exhibit number 1.
que están como
Before you signed these, did you go over them with Mr. Kimmler and the translator?
Antes de firmar esos documentos, sí te explico todo en español y su abogado también.
Sí.
Yes, Judge.
Do you fully understand those documents?
Y usted entiende todo que firmas. Yes, Judge.
Do you understand if I follow the agreement that you made with the district attorney that you'll be waiving any right to appeal?
Y usted entiende que si ella va con lo que firmaste que estás dejándote derecho para apelar el caso.
Yeah.
Yes, Judge.
It looks like the agreement that you've reached is for a 3-year deferred probation with a $300 fine.
Y lo que firmaste 3 años de probation y con una multa de $300.
Sí.
Yes, Judge.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest
Si usted no eres ciudadano, una publicidad de culpable,
may result in your deportation,
se pueden deportarte,
exclusion from admission to the country,
salir del mundo.
or denial of admission or denial of naturalization under federal law?
Tenemos que sí entiendes eso.
Sí.
Yes, Judge.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Torres Lopez is not competent?
Not enough observed, Your Honor.
Ms. French, what's the state's position with regard to waiving pre-sentence reports?
State will waive, Your Honor.
Right.
We waive also, Your Honor.
Right. State's one's admitted then. Mr. Torres Lopez, I'm going to find that you entered your plea of guilty freely and voluntarily.
Entiendo que usted entró su pecado libre y voluntario.
find that you're mentally competent and you understand the nature and the consequences of your plea.
que usted entiende las consecuencias de su caso
Find sufficient evidence to find you guilty.
y tenemos suficiente información para ponerte culpable.
However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do everything you're supposed to on probation, this is a great opportunity because you do not have a felony conviction on your record. If you violate any condition of probation, though, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand?
Yes, Judge.
I'm handing you the trial court certification that shows that this was an agreement I followed and that you've waived any right to appeal. Before you leave today, you'll need to talk to probation at that desk over there. And if you'll just help them get that information.
Yes, ma'am.
Thank you very much. You can go talk to probation now. Thank you for taking care of this. Jennifer, A-L-J-R-I? A-L-J-R-I. Jennifer. Yeah.
I'm sorry. Yeah. It's okay. I can get it.
A-L-R-A-J-A. It doesn't want to come out right.
It doesn't. What is A-R?
Look,
A-
hey Jennifer, when you're done, come tell her how to spell your last name.
A-L-R-A-J-I.
There we
Thank
go. See, it's easy for her to say.
And she can enunciate.
All right, Mr. Coleman and Mr. Gertz on Felicia Freddie. It was set for this afternoon.
Do something on the tab.
All right, so you are Felicia Freddie. Just wait just a minute. I'll be finished.
Okay, cuando llegue a salir la opción. Ese es el which is 120 pages. No, nomás van a ir a la otra predicción, pero das todo esto y ellos van a tener todos los cosas que están diciendo en un parte, cada mes para otro. Okay?
All right, this is clause number 24, DCCR 1390. Thank you very much.
Yes,
And so Ms. Freddie was previously in court. She's on probation for evading arrest or detention and
Judge, I'm sorry, Rob. It's actually, we reduced it to a fleeing initially.
Eluding.
Fleeing or eluding. I don't know why it keeps coming up as evading.
okay. And so it's a misdemeanor,
That's right.
put on probation. There was a motion filed. She pled not true to the counts in that motion. We were here we're actually set for hearing this afternoon. It's my understanding you guys have visited and there's an agreement reached. Is that correct?
Yes, Judge.
Yes, Judge.
So tell me what's going on.
I guess the way to call it would be a little bit of unusual agreement, but Mr. Coleman has agreed to dismiss the motion to revoke probation in exchange for essentially 2 sanctions. One would be having the court order her to do a day in jail, but with credit for a day in jail. And 2 would be to complete an anger management class through the probation department.
And it's the state's intention to dismiss the motion. And those would just be sanctions through probation, not because of me making any findings in that motion, correct?
That's correct. Essentially an amendment to her conditions of probation.
So, Ms. Freddie, what that means is that motion to revoke your probation is going to be dismissed. You're still on probation.
Yes.
It's going to be now a condition of your probation or a sanction for the allegations that you serve 1 day in jail. You will get credit for that day when you were arrested. Also, you will now be required to successfully complete an anger management class or program. I do want that started within 30 days. It's a kind of a lengthy several week program. I don't want you to put that off. I want it started within 30 days. Do everything else you're supposed to on your probation. And this will hopefully just be a hiccup that goes away, and you'll still be able to have that deferred probation without any type of conviction.
Yes.
Okay. And I know because it's a misdemeanor, it's also not a long probation. And so you need to get that anger management done as quickly as possible.
She's 1 year complete, Judge. And
Okay.
so, of a 2-year probation.
Perfect. So there's plenty of time for you to get that done. So get that started, get it over with, and then every property with previous convictions. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
I've read it, Your Honor.
I have, Judge.
Are there any additions or corrections?
No, well, one thing is it's an addition, and I just found out about it Friday. In the report, it says his mother abandoned him at 3, which is true. But she's now straightened herself out, and she's helping run a rehab center in Lafayette, and it's going to become part of his life. He's got 2 uncles here, so he has. They're in the courtroom. He has strong family support.
Okay.
A lot stronger than what that says.
Good. Thank you. I am also going to take judicial notice of the court's file. Mr. Smith was previously found not competent and was sent to the John Dunn Behavioral Science Center and restored competency. Any issues right now before sentencing with competency?
No, I think have you been taking your medicine in jail?
Okay.
I don't think so, Your Honor.
Okay, perfect.
Might have to be a psychiatrist to truthfully answer it, correctly answer it.
All right. So, Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of theft of property with previous convictions. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But that will be probated for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That is going to include being on the mental health caseload so that you can get whatever help you need. Follow all of those recommendations, meetings, medication, whatever. That's all part of your probation now. If you do all of that, this is a great opportunity for you to get your life back on track. And you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand?
Yeah.
I'm handing you 2 things. One is the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Adams.
Judge's misdemeanor will be dismissed.
Yeah,
Okay,
that's what I
thank
was
you.
going to say.
All right, so
Yeah.
those to get that misdemeanor dismissed as well as part of that this morning. Okay, good luck to you.
Thank you, Your Honor. He be released today.
He should be, yeah, as long as there's no other hold that misdemeanor. Once if there's nothing else in the other county, but if it's just this. Yeah, you should be released today, and you'll get some instructions today before you leave the courtroom for probation to tell you exactly what to do when you're released. Okay. Okay.
Thank you, Your Honor.
Yes, sir. Ms. DeLays, you have Jeremy Alexander.
Yes, Your Honor. It's out.
Good morning.
Good morning. So now rainy morning.
Yeah,
That's a lot of
very rainy. A lot. Morning. Good morning, sir. Are you Jermaine Alexander? And this is 26 DCCR 0178. Mr. Alexander is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Your Honor, we're going to ask for some more time. I'm still waiting for some discovery. I have not gotten any of the videos yet. I did talk to Mr. Smith about that. We're thinking they might be online, but they weren't given to me yet. So I'm going to double check.
Okay. So if y'all will both check on that. And so, Mr. Alexander, I'm going to reset your case so that Mr. Lage can get all of the videos and everything that the state has. And she'll be able to be out there hopefully before that next court date to go over all of that with you, show you everything. And then we can get an announcement at the next court date. Okay? You go back with the bailiff.
Thank you.
Thank you, ma'am. I could just put a notation, videos specifically. Yeah. Brian McWade, Mr. Macon.
Good morning, Your Honor.
Good morning.
Sorry.
Yeah. Good morning, sir. Are you Brian McWade? Yes, ma'am. And this is cause number 26 DCCR 0402. Mr. McWade is charged with aggravated assault with a deadly weapon. Mr. Macon has filed a motion asking that I set a reasonable bond. What is the bond currently?
$500,000. It was Tommy.
Were we here already on a bond?
That was the first motion I filed to try and lower the bond, and you denied it.
This is April.
Right. I usually don't.
22nd.
I usually don't do this twice.
Oh, okay.
Unless something, significant has changed. If there's some new evidence, other than that, it's just a matter of if the case is going to go to trial, then there can be a rejection and we can get it set as quickly as possible. But unless there's new evidence with regard to a bond, I'm not going to hear the same evidence again. The fact that he's still in custody isn't necessarily new evidence.
He has a job waiting for him with Neutron, right? As an electrician.
Okay. Ms. Malfino, does the state have
I apologize. This was formerly a 5A case, and I don't know if maybe it got piggybacked along rather quickly and it was not on our docket. If you could give me a few minutes, I'll either go get it. I would appreciate the opportunity to at least review it. Its court has already heard this. I'm sure my position will be the same as Mr. Coleman's original one.
Yeah, and it shows on my docket that it's Mr. Nichols. Is that not correct?
It may be, Judge. I think it was an add-on. I didn't have it on my docket, didn't have it pulled for this morning, but we'll get it good.
Okay, well, it's on the regular docket, so it wasn't added on too late, but maybe it was a week or so. Let me hold it for a minute. Just go back with the bailiff.
Some of that is the numbers changing in
Right.
the computer. They print out different numbers. Take a minute.
Mr. LeBlanc, looks like are you working on Derek Schinkel? Okay, I'll hold it. Mr. Rojas, you have Vicente Gloria.
We need
Hold on a second.
spoken this morning. I'm going to ask for a reset. I'm trying to run out some more information.
Okay, we're going to reset Vicente. We'll reset Vicente Gloria. John Hill.
John Hill.
Good morning. Good morning.
Good morning.
Good morning, Your Honor.
Good morning, sir. Are you John Hill? And let me get this pulled up correctly. Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Hill, in clause number 22-40932, I have an amended motion to revoke your unadjudicated probation. Shows that you were placed on probation March 28th of 2023 for the third degree felony offense of forgery of a financial instrument. Is it a third? The docket for some reason has state jail beside it.
It looks like it's a third, Your Honor, on the motion, on the admin.
Okay. I just want to make sure I'm saying the right thing because it has SJ on the docket.
It was enhanced, Your Honor.
Okay, so it was a state jail felony forgery that was enhanced to a third degree,
Yes, Your Honor.
and it was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of theft of property less between $100 and $750, April 15th of 2026. Is that true or not true? True or not true?
Because we can drop count 2, it's duplicative, it's injurious habits. We're committing theft. I'm sorry, we're going to drop count 2 just because it's duplicative.
Count 3 alleges that you're behind in your court assessed fees as of April 16th of 2026 in the amount of $10,859. Is that true or not true?
True.
Count 4 alleges that you failed to report as directed to the probation department for the months of April and May of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to remain in Jefferson County, Texas, and that you were in Orange County June 1st of 2026 where without permission. Is that true or not true?
True.
And then count 6 alleges that you failed to immediately report the arrest for theft of property to your probation officer. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
Give me just a second. I need to look back at some things to understand. I'm looking for the PSI. Also.
Is your question about head 3, Your Honor?
It's actually a third degree. It wasn't enhanced. It was not enhanced. It was a third degree forgery. That was amended back when he entered that plea in March to show that it was just the caption that was incorrect. Okay. Got it.
I'm sure.
What is the status of the new theft case?
It's pending, Judge. When this is over, we're going to take him down the hall and give him plea to that one as well.
I know.
I believe it's set this morning also.
I realize most of this history is very old. I just don't know that I love to pay 45-day sanction for someone with this kind of history for the same type of, it's a theft.
And Judge, if I can, the thing that he was stealing food, it's not like he was out stealing stuff to go, alcohol or anything like that. He and his son started a trucking company. He is going to be gainfully employed when he's released. And I think, as far as I know, the court's not really concerned about the money, but he did have an accident, which made it hard for him to stay up to date on probation fees. I think he's trying to turn his life around, Judge. I think like I said, he started the trucking company. That's a step in the right direction, I think.
All right. So, Mr. Hill, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for me to continue you on probation, but order a 45-day sanction as a condition, and with the caveat that you're going to go take care of the other case. There's going to actually be a plea. It's not getting dismissed, correct?
That's correct, Your Honor.
Is that your understanding?
Yes.
Obviously you can tell I don't love this agreement. I want to make sure you understand if I follow this agreement and you're in trouble and you're in here again on another motion, it's not going to go this way. Okay.
But I'm embarrassed.
All right. I'm going to, state tenders number 1.
No objections.
It's admitted any evidence that Mr. Hill is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, 5, and 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to order that 45-day sanction. And you will get, agreement is for him to get credit since the motion, right? The arrest on the motion.
Yes, Your Honor.
So you will get credit on that 45 days for any amount of time that you've been in since you were arrested on the motion to revoke. So not from the original part of the case, but just since you've been in on this. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. Take advantage of this today. All right, good luck to you, sir.
Thank you, Your Honor.
You can go back with the bailiff.
Yes, ma'am.
Okay, what's the name?
Pedro Martinez.
Martinez, Pedro.
Yeah. Good morning, sir. Are you Pedro Martinez?
Yes.
And this is cause number 26, DCCR 1085. Mr. Martinez is charged with assault, family violence by impeding breath or circulation. Mr. Rojas, what is the announcement?
Judge, if I may, have a name called and document a few things for the court's record.
Sure.
The name of the complainant is Margaret Samano.
Margaret Samano.
Margaret Samano. Margaret Samano. On, John.
Judge, may the record reflect that the complainant, Ms. Samano, has not appeared in court today. We're not surprised by that. I did make every attempt to reach out to her, known information I also asked my family violence investigator, Ms. Guidry, to reach out to her. It's apparent to us, from one, she non-prosecuted, so to speak, in the offense material, and two, I don't believe she has a permanent residence, and they have attempted to track her at some known locations for people who don't have a stable place to reside, unable to do so. We did find one email to her at a Gmail account. We made every attempt to send notification there to please contact us, both in English and in Spanish. She has yet to respond, Judge. Obviously, the nature of the offense is concerning with it being a family violence, but on the other hand, the fact that the defendant has been in custody, I feel with that information, it is my duty to, at this time, move to dismiss. And if further information comes to light, I will bring it to the court's attention.
Okay, then I'll sign that. Obviously, Mr. Martinez, I'm taking a look now at that probable cause affidavit. So something went on that night that shouldn't have gone on. And the fact that she isn't cooperating makes me very concerned, but it is what it is. If you end up back in here, or if she changes her mind, they could re-indict your case, but whatever was going on you need to stay far, far away from that.
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Justin.
I'll sign it as soon as it comes through. Jamie Story. Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tenors number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and
What started as a routine court appearance quickly turned into a powerful lesson about respect, accountability, and the consequences of every choice made inside a courtroom. Whether you agree with the judge's decision or not, one thing is certain: how you conduct yourself can have a major impact on your case. If you enjoyed this courtroom breakdown and want more real legal moments with expert commentary, be sure to like, subscribe, and turn on notifications so you never miss the next case.